that she wanted to go back. So the idea of sense of fear tends to be diluted or negated when she actually decided to travel from assuming the exit point downstairs and go all the way up upstairs to meet Mr. Aleo. I think it says my phone dropped out. Okay, I'm back. To go up to meet Mr. Aleo, her alleged, assault or assaults her here as minute or last hurrah of a consensual sex belief of a goodbye after that. The only sense of confinement was a hug, and that she feared that she couldn't leave his grip or his grasp. Last we shoot up, so I asked that there is no determination of false imprisonment and that none of the elements was met on behalf of the state. Last we go look up at rape in the carnal knowledge without consent. There's obviously no way to confirm or disprove that the video that was posted on Twitter is the same as the video, and obviously would be from testimony would be differences that this was that. So the only thing we have is a statement from Ms. Noel saying that sex did have, and Mr. Leo, who consented that they did actually have sex, and his belief that it was consensual. She said that it wasn't consensual, no questions or anything was testified about any previous sexual as a way to make a difference, DNA, because we both know that they have sex. So here we just basically have the he say, she say that they did previously have sex, they agreed to have sex, and another statement saying that they didn't have sex. So I feel that there's not enough evidence presented in either or nor cases that we have presented today, and that all cases should be dismissed and dismissed now and not to be further pursued up to Superior Court and down the road.
Ms. Palomino, argument?
Yes, Your Honor. And addressing the prohibition on
this DA,
electronic
hard.
transmission, we do ask the court to bind all three over as felonies, even though one of the warrant was for misdemeanor. I think Mr. Eady is kind of misplaced when he recites the law. The law doesn't require that the videos that are posted and the content that's in the videos be of consensual nature. It requires that the person did not consent to the posting of those videos. And as long as those videos were electronically transmitted or posted, whether it's a photograph or a video on some type of social media website, sharing site or web page or message board, if they were posted without the consent of the victim that's in that video, and they were posted for the purposes of harassing or taunting the individual, and it shows explicit conduct, then it's a felony, and that is probable cause for the warrant for that, and it should be bound over. You heard the testimony from Detective Panosian. Ms. Newell did not consent to the posting. This was posted after she left, and what she believes was in response to her leaving the group and potentially being taunted and harassed. We've submitted evidence about what the cult culture was like with Mr. Bishop and what he would order and demand and require his members to do when people left or disrespected him. And so based on that, there's enough probable cause for the prohibition on nude or sexually explicit electronic transmissions.
So it looks like they're giving up on the rape.
And moving forward to the rape and false imprisonment, there's also enough probable cause for the warrants on these cases, and we ask that those be bind over as well. The fact that I think the defense tries to make it a big deal that Miss Newell has left over the years and come back to the cult, I'm sure this court's familiar with domestic violence relationships and how individuals will leave and go back routinely because of the hold that someone has over them, because of the threat, the fear that they have for their life. This is a situation in which Miss Newell was part of a cult, and where the Mr. Bishop, who somehow self-proclaims himself as God, as the leader of this organization, orders and controls other individual members in the group. And when they didn't do what they wanted him to do, when they didn't do what he asked of them, he would order some type of physical violence toward them. So there was a culture of fear with Mr. Bishop. This is evidenced by multiple videos that Mr. Bishop himself has posted, that other members have posted, that Detective Panosian testified that she has observed. And Miss Newell, at the end of the day, said that she told Mr. Bishop no multiple times. She told him that she wanted to leave. He held her, said that she could not leave, and specifically said that she was his property. and that she would not be allowed to leave, and then proceeded to rape her without her permission, engaged in intercourse with her without her permission. She essentially said no multiple times, and then
my wine journey started in college. It's a white male-dominated space. I'm a black male.
coercion or duress is not consent at all, especially when there is fear surrounding it. So based on the testimony, based on the evidence,
that's a reach. Come on now.
There is enough probable cause for all of these charges to be bound over to Superior Court.
Come on now. Come on, Edie. You gotta say something,
Thank you very
Edie.
much, lawyers. Based on the evidence and testimony, I am going to find that the state has met its burden. With respect to the electronic transfer of the videos, the detective testified that she saw 3 videos of the alleged victim and the defendant here engaged in sexual intercourse. And it was a surprise to me that Twitter allows such videos to be posted. But the consent with respect to the law does not belong to Twitter, it belongs to the victim. And the victim here reported to the detective that she did not give consent. And so whether or not there was consent, I think is a jury issue. And so a trier of fact should determine whether or not it was done with consent or without consent, since both parties have two different stories. And so I am going to bind those over. Now, with respect to the difference between the misdemeanor and the felony, I haven't heard anything that would make me want to change these charges, because the statute states that it's a felony under B1A to post it to a website, and then it's a misdemeanor if it's posted via other electronic means. I haven't heard what whether or not there are other electronic means, and so I'm not going to modify that charge. With respect to the rape charge, I do find the state has met its burden. Ms. Newell indicated that she wanted to go back and say goodbye for whatever reason, whether it was his request or her decision. But her testimony, or at least what she reported to the detective, is that the defendant told her, "You my property, you my bitch, you're not allowed to leave." And he started holding on her and wouldn't let her leave. That's her testimony. And so a trier of fact gets to determine whether or not that testimony is credible, or whether or not to believe that Mr. Bishop did not see it as a rape. Since he did admit it to the sex, he didn't see it as a rape, she does. That's a jury question, and it has to go.
God damn, man.
With respect to the false imprisonment, I believe there is sufficient testimony. Not only did the victim report she couldn't leave, but the person who called the Uber, she had to call them and say, "Look, I'm gonna have to sneak out at some other time." So I think that's enough to go in front of a jury and let a trier of fact determine.
It's too many. It's too. Look how many women there. Like
so that's why I do find that the state has met its burden, Mr. Bishop. All that means is that your case is going to be bound over to the Superior Court. Now, Mr. Edie, because of the rape charge, it's the Superior Court only bond. I can't do anything about that bond or any of the other bonds. So, Mr. Edie, anything else on Mr. Bishop?
No, that would be a judge.
All right. Anything else from the state?
No, that is it, Your Honor.
All right. So, Mr.
Panosian and I be excused once this concludes.
Mr. Bishop, that concludes your probable cause hearing. I'm going to ask that you follow the direction of my deputy. It looks like you have a question. You have a question for your attorney? Certainly you don't have a question for me.
Yeah, I got a question for you.
All right. Let me remind you, sir, and I'll ask the deputy to go ahead and unmute. Let me remind you, sir, that this hearing is still being recorded. So whatever you say here today will be recorded. If you say anything about your case, it will be used against you at a later hearing.
His lawyer should tell him, shut the hell up.
Let your attorney speak to you, because if you do have a question for the court, I would advise against it. But I'm going to let your attorney speak to you before I hear from you, sir.
Please, thank you.
Mr. Edie, would you like to speak with Mr. Because he has his hand up. I don't know what he has his hand up for.
If it can be in a breakout, then yes. If it's not in a breakout, then no, I would not.
Here's my problem. My next hearing starts at 10 o'clock.
Don't say shit.
If I had enough time to put y'all
Don't say shit.
I would do that.
You got a lawyer. Let your lawyer talk for you. Don't say shit. Please don't say shit.
If it's going to take more than 1 minute then that's gonna make me late for my next hearing. Let me check with my assistant.
Don't you do it. Don't you fucking do it. Don't do it. Don't do it. Don't say shit.
Okay. Well, Judge, I just on the record that I advise against any statement to be made, for Mr. Alejo to make here on the Zoom here. So I would just be against my advice, and I would just let him know that I would not advise that.
He's telling you shut the fuck up. That's what he's telling
you. You've heard from me. You've heard from your attorney. You still want to address the court, or you still have a question?
Thank you.
I think that's
it's not going to help.
I'm going to ask that you please follow the direction of my deputies and lawyers and detective. You all are excused.
Thank you, Judge.
Thank you, Judge.
All right.